Cool. All right. I know we've got some people trickling in here, but I wanted to introduce, I'm speaking on behalf of Linda Narhi, also on the call here today, and myself. We are the chairs of the Industry Liaison Committee that serves the Bioengineering Institute of California. And this is one of our fantastic career panels that we're excited to welcome everybody to tonight. We wanted to tell you a little bit about Bioengineering Institute of California. It really is a way to unify all 10 of the bioengineering and biomedical engineering departments that exist across the University of California system. And here are some of our goals in the middle of the slide here, but what we really want to say tonight is we want every student to have access to all of the amazing professionals that exist throughout the state. And one way to do that is through tying together all of our BME and bioengineering departments. So with that, I'm going to turn it over to Professor Song Lee from UCLA. He's the chair of the department and also the chair of the Bioengineering Institute of California. So Song.
Thank you, Walt. So this is a great event. It's part of the California Academy of Engineering in BIC-sponsored seminar series. It has been kind of a tradition for us in the past year or so, especially through the pandemic. I want to thank Walt and Linda for leading the Industry Liaison Committee, and also all the panelists here for the contributions to this webinar. I really look forward to it. So now I'm going to turn it over to Rabbi Nazula, who is the host of this panel. Thank you.
Great, thanks. Let me pull up my slides. How's that look? Did it pull up okay?
Yeah.
Great. All right. Well, thank you, everybody, for attending our seminar. As you know from the invitation, we're going to talk about 5 things that we think every bioengineer should know about patents. And towards the end, we'll talk about careers in patent law. We have a great panel here of a lot of people involved with bioengineering or biomedical engineering or medical devices in general. And so my name is Ravi Narula. I have a background in mechanical engineering. I've been practicing law for about 25 years and primarily in the medical device space. So what I think I'll do is just real quickly have each of the panelists give them a brief introduction. And we're going in the order of the slide here. So maybe we'll start with Monica, if you just give us a brief introduction.
Hi, I'm Monica Arnold. I'm currently at Armand Wilson, which is a IP boutique litigation firm in Newport Beach. My background is my formal education is in pharmacology. I also worked in electrochemistry in my postdoc. And after my postdoc, I decided to go to law school, and I did have the opportunity to be a clerk for a judge for a year after law school, and now I'm at Armand Wilson. So I've done a few things.
Brian?
Hi, everyone. Brian Wall. I'm the general counsel at Tarsus Pharmaceuticals. It's a publicly traded pharma company, and we've developed the very first treatment for Demodex blepharitis, which is basically mites in your eyelid, and it's FDA approved. Prior to that, I was a partner at Kobe Martins, working with Ravi. Ravi is one of my great mentors. I was working there for over 15 years, and prior to that, I was a physician in internal medicine, and then went to the dark side law school after that. Great to be here.
Jessica?
Thanks. Hi. Yeah, I'm Jessica Hudak. I'm currently lead counsel and team general counsel for the Advanced Technology Business Unit at Edwards Life Sciences. I started my training in mechanical engineering at University of Michigan. Then I went to Stanford, where I got my master's in biomedical engineering. And that's where I fell in love with patent law and decided to start working as a patent agent. And then loved being a patent agent and decided to go to law school. After law school, I clerked for a judge at the Federal Circuit for a couple of years. Then I did litigation at a law firm called Gibbs & Dunn. And then I moved in-house about 2 years ago. And I'm really loving it. Happy to be here.
Iman?
Hi, everyone. My name is Iman Hidari. My formal training was at the University of California, Irvine. I have my PhD in biomedical engineering. And then I postdoc there with Brian Wong at the Beckman Laser Institute doing some electrochemistry work. After that, due to my inventiveness during grad school, I fell in love with IP, particularly patents, which then led me into working for Wilson Sonsini as a patent agent. I've been here for 3 years. And I've also been partaking in their PALS program, which offers tuition reimbursement for individuals to go to law school and work at the same time, which we can get into later. But loving it. The legal field is fantastic, as I'm sure you'll understand from our presentation. Happy to talk to all of you.
Great. So now we'll get into the presentation. Just a quick caveat, because you have a bunch of attorneys on the line. We're providing a high-level summary of a complex area of law. So obviously this is for educational purposes. If you ever start inventing something, I think one of the best advices is to contact a patent attorney as soon as possible, as you'll see as we talk about some of the deadlines that come up. So the 5 things we're going to talk about are: what is a patent? How do you get a patent? When to file a patent application? Who owns the patent, and some offensive and strategic considerations about patents. And each of the panelists will kind of tackle each one of these topics. And at the end, we'll get into a little bit more detail about careers in patent law, what we like about it, what you might be interested in case you're interested in it. Hopefully we'll have a chance for some Q&A too during the presentation. So with that introduction, I'm going to turn over to Iman, who's going to give us kind of a high-level overview so that everybody's on the same page about what a patent is. And panelists, just tell me when you want me to switch slides.
All right. Thanks, Robbie. All right. So a patent. So this is it's a document that provides a exclusionary right. So oftentimes there's a misconception in terms of what a patent actually provides. And what it is indeed that you're receiving is the right to stop someone else from making, using, selling, importing, or effectively operating and doing what the patent claims describe. And that is a 20-year period of exclusionary right that the patent provides from the non-provisional filing date, which we'll get into in a moment in terms of the timeline of when there's provisional and non-provisional applications. And the patent itself is actually something that has to be enforced. So once you've obtained the patent, you have to then go and enforce it if you'd like to stop someone else from doing, making, using, selling, importing what the patent claims itself. And it is a legal document, so you will receive a formal issued patent document from the U.S. Patent Office as well. Next slide, Robbie. So what can be patent? There's a statute, 35 U.S.C. 101. We don't have to get into the nitty-gritty of the legal details, but on this slide we have a broad overview of what those different types of categories of inventions that the government has classified as being patent eligible. And so in broad strokes, we have devices, systems, methods, compositions of matter. There's also business methods. There's also something called design patents, which cover the ornamental design of an object or a user interface. And there's also, general methods of manufacturing or a procedure of operations that can be also patented. Those are called method patents. And so the next slide, we have some detail around artificial intelligence, since that's a budding hot area. I've done a very brief case study of approximately 100 issued patents in the last 5 years. And we found various categories of patentable artificial intelligence claims, and they're outlined here. So we have a use of a trained model, where the patent claim itself that provides that exclusionary right we were just talking about includes the recitation of the data that is inputted into the model and the corresponding output, and the data that is used to train the model. So that's one category of type of AI patents. And then we have training a model with explicit recitation of the training data, and then applying such model to receiving a concrete output of a diagnosis, classification, or prediction. And lastly, and generating the predictive model itself. So we have different flavors of ways of protecting things that would otherwise seem to be abstract ideas that otherwise would not be patentable, or laws of nature. And so it's good news for the budding field of AI in that there is promise to have patents in this field. Next slide. For the non-patentable intellectual property, there's various categories that you see here, one of which is trademarks. So trademarks is kind of quite a broad category of protection that can be afforded to various slogans, designs, logos that have a product source identifier, so that these protectable aspects of trademark identified, excuse me, these aspects of trademark then protect that source identifier of that particular design. Copyright is an interesting intellectual property right in that it protects our works of expression that are fixed in a tangible medium. So oftentimes our works of art are then determined to be copyrighted when the artist produces them or creates them. And then lastly, we have trade secrets, which are more in line with, for example, the Coca-Cola formula, which has been protected and has not been disclosed in the public whatsoever. And so companies are able to enforce their trade secrets through actions such as trade secret misappropriation, where they're able to essentially allege that an individual that was privy to such protected information has now misappropriated or taken that and publicized it. And so there's various other ways of protecting your intellectual property besides patents. Next slide. Oh, okay. So this is our next panelist.
You're on mute, Ravi.
Yes, Jessica. So tell us, how do you get a patent?
Great, thank you. So thanks, Iman, for your introduction. And so how do you get this patent that Iman told us about? So there's two things to think about. One is the process you go through, which is kind of outlined here. And then the other, which I'll get into later, is what are the requirements for getting a patent? Iman touched on some patentable subject matter issues, and I'll get into a few others. So first of all, the general timeline. Most people start with a provisional application. It's a great way to essentially set your place in line, get your priority date in line, and prove that by that date you had invented this concept. And it gives you 12 months where you can stay under the radar, doesn't publish, everything's confidential, and then you get that extra early time. It also gives you 12 months to work on the product more, test it, make sure it's worth the investment of filing a patent for, and maybe you've learned some new things along the way that you want to make sure you get into your patent. So then the next step is the non-provisional patent application. And then 18 months later, and that's actually 18 months from the provisional date, the application will publish. And so something to keep in mind there, that it will be a public record. And so your competitors, everyone will be able to read what you're working on and read what your invention is. Of course, that's by design. That's why we, you get the exclusivity for a time, because you're teaching the public how to use it. Once the application goes through publication, it can take anywhere from 2, or I've seen some go 5 years or longer, but things seem to be moving a little faster as the patent examiner does his or her work. And what that means is the examiner will search patents that are out there, publications that are out there, and let you know the scope of what you invented. Can you get a really broad patent that covers, whole fields? Or do you have to narrow it in because there's other patents out there on your more specific invention? And then you'll get a notice of allowance, and a few months later, the patent will issue. And then you will have this legal document, as Iman said, to use if you want to engage in litigation and enforce against others and get them to stop making or using your invention. Next slide, please.
And Jessica, can I ask you a quick question?
Yeah.
I know a lot of people say it seems a little scary that it takes 2 to 3 to 4 years to get a patent. But I know you're familiar with a tool that you can get it faster with. And so I thought maybe it might be a good time to kind of talk a little bit about track 1. And
yes, thank you. Thanks for bringing that up. So yeah, this is a great option. And so what track 1 means is you file your patent application within this track 1. You let the patent office know that you want to have expedited application, or expedited review. And they promise to give you a final action, whether that's a final rejection or a notice of allowance. Obviously, you want to be going for the notice of allowance within 12 months. Typically, the way companies, especially startup companies, use this process is they will get a relatively narrow claim because it's easier to get a narrow, more specific, more detailed claim towards your invention. And you'll be able to get that quickly. So then you can show the world, show investors, show potential partners that you have this invention, and you can get it quickly. And then you can continue to file more applications, and we'll get into that, and go for broader claims down the road.
Great. Thanks.
All right, so provisional application, we touched on this a little bit, and as the first bullet point says, and a really important thing to think about is this always expires in 12 months, and it will never issue in a patent. So the only way to secure that priority date or your option to file this utility patent is you file a patent within those 12 months. Some other nice things I mentioned about the provisional, gives you an early date. It lets you, get your application on file while you continue to invest. But it also doesn't require all the formalities, and the filing fee is smaller. And so again, this is a great option for independent inventors or small companies. But remember, you've got to set that date and file something within 12 months, which is another reason it's great to have an attorney, because they can help you track those dates as well. And what's interesting about having a provisional, as soon as you filed it, you can start marking your products patent pending, which again is a good signal to competitors, to investors, that you're taking this seriously. And as you can see, the cost is listed here. The 250, 260 around in there, those are the filing fees. Those are the administrative fees that you'll pay no matter what with the patent office. Then you can see there's a really big number there, $15,000. It can take, it can cost that much for an attorney to draft a really great provisional application. And sometimes it's worth it, because if your provisional application doesn't cover everything you need it to cover, you won't actually get the priority claim to those things that weren't covered in the provisional. But that's not always possible given the price tag. So something to just think about and weigh as you're making those decisions. So next slide. Okay, so now let's break down a patent. I'm sure most of you in our audience, engineers, have seen a patent or heard of a patent, maybe even done a Google search on a patent. And so you can see on the right of the slide here, that's what a patent looks like. And it has all the details, inventor, title, who owns it, all at the top, patent number, all the important dates and things like that show up at the top. But then as you flip through the patent or scroll through it, if you're reading online, the next thing you'll see are the figures. So that's kind of the second bullet point there. And it's required that the figures show every element that you're trying to claim. So all the key elements of your invention have to show up in the figures. As you continue to read through the patent, the next thing that comes up is the description, or sometimes it's called the detailed description. And those are the prose, those are the paragraphs that talk about each of the figures, referring back to the figures and really providing a lot of detail about the invention. And as you can see here, we've got 2 bullet points. The patent must be written in full, clear, and concise terms in order to enable one of ordinary skill in the art to make it. And then the patent must also describe the best mode. So with those 2 things, we're starting to get into some of the detail around patent office requirements. And the first one, both we call that written description and enablement in our world. And those are required because the patent office doesn't want you just submitting, and best mode as well, they don't want you just submitting part of your invention and then trying to exclude others from making the whole invention. It really is an exchange with the government. You give all the information to teach the public, and then they'll give you the term of exclusivity in exchange. So that's one of the requirements you have to meet. It has to be fully described. And then last, at the very end of the patent, are the claims. Those are numbered sentences that show up at the end of the patent. And those really are, that's kind of the crux of the patent. That defines the scope of your invention. And if you try to exclude others from making and using your invention, the court is going to go directly to those claims and see what you actually own. And does your competitor actually Have they actually started using what you're making, or as we say, infringing the claims? So those are the various parts of the application. And one last point on this one, the claims is where the patent examiner will actually spend the majority of her time, because that really honing in on the proper scope of those claims is really what you're kind of doing the back and forth with the patent office. You're fighting for broader, they're saying you need to go narrower, and it's really this compromise to find the ideal scope of your claims at the end. All right, next slide, Rob. Thanks. Okay, so to be patentable, as I said earlier, there's the application process that you have to go through, just the administrative process of kind of the back and forth with the examiner. And I also mentioned, or Iman mentioned, there's patentable subject matter. You can only get a patent on certain categories of inventions. Most of you probably will fall into patentable subject matter, given your backgrounds, but always something good to think about. And then, as I said on the last slide, your description, you have to describe your invention fully and really enable someone of ordinary school in the art, or a person out there in the world who would know about this field to make and use your invention. So if you meet all of those threshold requirements, that's when you get into the meat of this patentability analysis. And this is what the examiner is going to be looking at, whether or not your invention is patentable and how broadly patentable is it. So the two big ones are, it must be novel and non-obvious. Novel means no one's done something exactly like that before. So it's pretty clear. If you have someone who's done exactly what you've done, you're trying to get a patent on it, the patent office won't let you do it. It's not novel. Non-obviousness is a little bit more kind of gray area. Really what that comes down to is there's not an exact ringer in the prior art, but maybe there's a couple things that if you put those together, and it would have been obvious for someone of skill in this field to put those things together to create your invention. The patent office doesn't want you to have a patent on that either, because they don't want to be giving out patents on things that someone in the skill of the art would have just been able to put together. And so those are really what the examiner is going to be looking through and giving you rejections related to those two factors. And I've said the word prior art a few times now. Really what that refers to is any patents that were filed before yours, printed publications, for example, scientific journal articles, medical journal articles, conference presentation, poster boards, grants, really anything that's printed and out in the world. And then prior sale. If you try to sell your invention before you file your patent, you could actually get yourself in trouble and lose your priority date. And same thing for using it publicly before you file your patent. So it's really important before you start meeting with investors, before you start presenting your invention broadly to wide audiences, is really think about either filing a provisional application on your own or talking to an attorney to help you do that, so that you don't run the risk of creating prior art against yourself. I think that's it.
Great, thank you, Jessica. So now we're going to turn to the next section for Brian. And so Brian, what about the rest of the world? We've been kind of talking about a US patent and getting US patent rights, but we live in a very global economy now. How do you get patents in the rest of how do you get a patent in Europe and China and all those other places?
Thanks, Robbie. So it sounds like a great idea in theory to protect your invention as much of the world as you can. But in practice, it's very typically cost prohibitive, especially long term. So you really have to be selective in what you choose, if anywhere. One efficient strategy is to file what's known as an international placeholder patent application within 1 year of your initial US filing. And that's known as a PCT, which is a patent cooperation treaty application. And the way to really think about this is for maybe $5,000 or thereabouts above your typical filing and attorney cost fees, you get an option and you preserve the rights for up to about 18 months to file discrete applications in the vast majority of specific territories around the world, including Europe, China, Japan, and others, for example. Things get way more expensive after the 18 months plus the 12 months, after 30 months. So at least you get the time to seek investment and gain proof of concept and maybe more on the rest of your business before you have to decide on these expensive international patent application decisions. Next slide, please, Harvey. So when do you file your patent application with respect to international ones? And if you want to preserve the right to patent your invention, the best practice is to never make a non-confidential disclosure before filing a patent application. For example, you may be motivated to publish positive bench research, clinical data. You may want to bounce ideas off colleagues, present abstracts, posters, or slide presentations at the next conference. Don't do it. If you undertake any of the activities prior to filing the patent application, you may have made a patent disclosure and lost all of your patent rights in most countries around the world. So remember, file first before making any non-confidential disclosures, and be sure to use CDAs or non-disclosure agreements in order to help protect yourself in that regard. Also, one thing to keep in mind is that some journal articles make e-publications before they actually publish, and that can also constitute prior art, as Jessica alluded to earlier. And here in the US, there's a limited grace period of up to a year, which you see on the top part of the slide, where you may be able to file a patent application after you make that published disclosure, even if you've already given up most worldwide rights. But best practice is not to do this. This is kind of like a emergency measure of kind of salvaging whatever rights you have. So always make sure you file first before you make any public disclosures. Next slide, please. So this slide gives you the relative cost of a US patent portfolio only versus a select international patent portfolio. And there you see from the chart that international patent filing costs increase exponentially over time. So you really have to think about incremental investment there instead of like R&D or clinical trials that may potentially move the needle more as far as investment. And the vast majority of time, because of healthcare quality and attractive pricing and reimbursement here in the US may be far and away your biggest market. Remember, you don't need a patent to sell in a specific territory. And you have to balance the costs of obtaining and maintaining that patent, which can be a lot, as you see in the chart here, versus the cost of enforcing that patent, basically litigation or other measures in that territory, and the probability of success against potential knockoffs. One quick story is that I was doing diligence several years ago for a venture capital firm on a medtech startup. So we were considering an investment in that startup. And that startup was really proud that they had patents in 25 or so countries. And they spent literally millions of dollars on international patent filings. And it's all great, but they had no idea if the product actually worked yet. So it's possible to have too much of a good thing. So again, just be sure that you modulate your international filings. Next slide, please. So here's a list of the top 10 countries for cardiovascular treatment device publications, and the list of commonly filed countries around the world. It can really vary according to your industry and the demand and reimbursement and a host of other factors. But in general, your top three are Europe, China, and Japan in that order. Market research is typically the most important. And one strategy to use is that if you see a strategic acquirer or a competitor of yours, you can find out what their international patent strategy is by looking at their filing patterns, and your patent attorney can help with that. And consider mirroring those filing patterns to give a perception of synergy that you're thinking of the same strategies that they are. Next slide, please. So deadlines. So kind of like we talked about earlier, the US, like most of the rest of the world, is what's known as a first to file patent country. That means if you and somebody else independently came up with the exact same invention, the first one to file your patent application with the patent office wins. In other words, even if you were second to invent and the first person thought of the idea and conceived of it before you, they may even wrote it in a lab notebook, but if you beat them to the patent office in your filing, then you would win. So it's important to file early and often if you can. And this kind of goes again to reinforce it. File early, file first. You don't need to have any clinical data. It's best to just sometimes use educated guesses as much as possible. And because one of the requirements is that if you can enable the invention, so if someone of ordinary skill in the art, similar to you, would be able to look at your patent application and sort of replicate what you have, that's all that you need. So a lot of times, educated guesses, prophetic examples are important strategies to put in your patent application.
Great, thanks, Brian. So this question is kind of open up to all four panelists, but maybe just talk a little bit about, if anybody wanted to jump in, about the product development timeline, like how, when you're thinking about when somebody comes to you with an idea, are you filing pretty quickly? What's your general thought on that? Are you filing, do you need a prototype before you file? Can you just file based on ideas? Any panelists want to take that on?
I could start. Typically my practice over the years has been file early, actually writing down in such a way that the patent is, has a detailed description and enables one to build it. That's actually considered a reduction to practice. So the patent office doesn't require you to have built anything yet. And so filing early is great, exactly for the reasons Brian said. It can get you into trouble if you talk to anyone not under NDA before you've filed. And then typically what we'll do is, have the important first patent application, maybe it'll go on track one. And then as you raise money, as you can see this kind of green in the middle, you can start spending more and more on patent applications, and it kind of goes along with as you're learning more about your product. And so the patents will be closer to what you anticipate your commercial product to be, and continuing to file patents along the way as you're changing the product and learning more about it.
That's great. Yeah, I often kind of the idea there is you often file on improvements. And I often have this kind of thought that for many of my clients, the first patent application is important, but often the second or third application where you really learn how the product works and you really have improvements kind of fleshed out, sometimes can be the most important patents because they kind of have that, they finally got the part that made it work, if that makes sense. Anybody else have any comments just generally on the kind of product development timeline and working with startups? See, Iwan?
Yeah, definitely. Thanks, Robbie. One thing to note is that when you file a provisional application that we've been discussing, this application actually does not publish. So you actually are afforded the opportunity to kind of keep filing provisional applications, as things improve. And then you are given that 1-year period from the filing of your provisional application to then convert that to a non-provisional application. So you kind of in effect can file subsequent improvements to that initial application within that 1 period as well. And then moreover, you could also just not convert the application to an application that would eventually publish if it's not ripe yet for enabled disclosure that has also been discussed. So there's kind of some other mechanisms that can be utilized, to keep your place in line, but not to necessarily go fully through the process until you're ready. And then that application that you do decide to go down the route of a non-provisional application to prosecute to get your patent can then claim priority to all of those provisional applications that you have filed from the first one all the way up to that 1-year mark. So this kind of designed to encourage that incremental improvement in process.
Great. I think my record is maybe 9 provisionals in that 1 period. I don't know if anybody has more than that.
That's pretty impressive.
Yeah. All right. Yeah, there's another slide here. Brian, I know this is a slide you presented on before, so maybe you can give us a little thought on how much you're thinking about, like valuation versus how much to invest.
Yeah, Robbie. I think, I used to have a lot of clients that are engineers and physicians. They got a great idea and they were just like, all right, I'm just going to file a patent application and I'm going to license it to a big strategic for millions of dollars. But, you may have heard stories about that 30, 40 years ago, but it's, I think, almost impossible to do that today. It's not really a lottery ticket. So you really have to invest in proof of concept and prototypes and maybe some animal studies, for example, freedom operates. You really have to sort of develop that business. And generally, the more you put into it, the more you get out of it. But it takes a lot of time and resources in order to get there. So early on, provisionals just generally, even if it's a big market, it's really hard to get valuation for it unless you do all the other things on this slide in general.
Great. Well, we'll turn to Monica on kind of our last couple of topics. About the first one is who owns a patent?
Yeah. So like Robbie said, I'm going to talk about patent ownership and then, ways to utilize those patent rights once you own a patent. So I want to take us all back to the front page of the patent. There's a lot of information on there. As it relates to ownership, there's 3 categories on the face of the patent that are important. So we have the applicant, which is the person or organization or entity that filed the patent application with the patent office. Then we have the inventors, who are sometimes the person who filed the application, and then the assignee. And the assignee is the patent owner at the time the patent issued. And this can change over time because patent rights can be given away, as I will get into. But for our purposes, it's just important to know that if there is an assignee on the patent, which there may or may not be, that party could change later. And so with that, can I get the next slide, please? Okay, so the default in US patent law is that the inventor is the owner, but as we've discussed, that can change. If you're a startup, you would want to have all your employees sign what's called a patent assignment agreement to make sure that any patentable inventions that come out of any work done by any of your employees stay with your company and they don't take it with them if they leave. And so this is a contract. It would be a part of an employee agreement that would have other provisions unrelated to patents. But the idea is you want to make sure that that assignment agreement is written in a way that to ensure that it's legally binding later in case you have to enforce it. So that's where the lawyers come in. You want to make sure it's written in a particular way. It's one of those lawyer things. Present tense is important for these. And it's also really important that anybody that's working on anything, independent contractors, consultants, individuals involved with joint research projects, anyone is signing these agreements to make sure that all the patentable inventions that come out of any work done with the company stay with the company. And so with that, I will go to the next slide, please. Okay, so now that you have a patent and you own the patent, what do you do with the patent? Well, there's lots of things. So I wanted to give one example. One thing that one can do, like what the University of California does, is you can license patents and obtain revenue from those license agreements. So a license agreement is an agreement between, in this case, the University of California and other parties like, other private companies that would like to have the rights to use the technology that would be covered by the patent with the permission of the university to create new products or technology. And so the way this works for the UC model is, inventors that are working through the UC system, like PIs, postdocs, graduate student researchers, undergrads sometimes, will submit an invention disclosure form saying, hey, we think we have this really cool idea. We think it should be patentable. And you describe a little bit about it. The university takes it. They say, hey, you know what? You're right. Let's file a patent application. So the university will file that application because all the researchers that you say or the university system have actually assigned the rights through a patent agreement to the university. And then if you get the patent, then that patent can be a potential patent that other companies could license from the university. And in exchange for getting to use, in exchange for that license, the companies that license the patents will then pay the university royalties and other types of fees. And all the inventors on those patents get a cut from those royalties. And so in 2022, the University of California owns over 6,300 US patents and over 7,300 foreign patents. The leader in the pack was UCLA, followed by San Diego and then Berkeley. And in that fiscal year, the UC system also issued about 375 patent licenses and generated over $127 million in revenue from royalties and fees from all those licenses. So it's a great way to commercialize patent rights. One way to do that is through licenses. But there's other things, as I think was alluded to earlier in the presentation. Yeah, next slide, please. Thank you. So besides licensing, there are other things that we kind of put in the bucket of offensive strategic consideration. So using your patent as a sword. As the other speakers discussed, the patent gives you a right to exclude others from making, using, or selling the patented invention. And so, if you, in your technology space, you notice that there's a competitor that has a similar device that you think includes components to it that infringe on your patent, you can send them a letter and say, hey, we think your wingding infringes on our patent. Please stop. Or, if you're interested in licensing, we're interested in having that discussion with you. Sometimes that works, sometimes it doesn't. Sometimes as a patent holder, you have to enforce your rights through a patent infringement lawsuit. That's where you sue this competitor for patent infringement in federal district court. And you're accusing them of, their technology is using something that you have as a patent claim. And so they shouldn't be doing that without your permission. And you would like the court to rule on that and hopefully win in your favor and tell them to stop doing that. And you can potentially get money for any economic losses that you may have received because, there was another competitor in the space. They were taking away sales from you. You should get that money, assuming that the court or the jury found that they were in fact infringing on your patent. So some other less adversarial things that one can do offensively is something called patent marking. So if you have a device that's patented, sometimes it's possible to actually put the patent number on that device. Sometimes that's not possible. Some companies, depending on what is being patented, will have on their website a list of products and what patents are covered by those products. It's a way to provide notice to the public that these certain devices or maybe methods, things of that nature, are protected by patents. So it's just letting people know where your fence is, which is leading into the next strategic consideration, which is defensive strategies when considering patent protection. So patents can also be a shield. And like we said, this is a patent provides for the right to exclude others. If you recall in one of the earlier slides, we had that product development timeline, and Robbie discussed how, early, the first patent maybe covers a prototype, and as you have time to tweak and learn more about whatever the technology is that you're working on and have more time to develop and modify your device or whatever it is that's patented, you file more patents to cover these iterations or these improvements that you've discovered as you've been able to spend time with this product or device. And so, that knowledge should also be conferred in additional patent rights to accurately reflect, what your device actually is after it's been through development or clinical trials or whatever. So you get to keep your eye on what's going on with your device and how it's being developed and improving, and you continue to file for patent protection for those iterations as it gets more developed. And so that is a way to signal to competitors like, hey, here's our fence. We have patent rights, we have property rights to these things. So, you stay on that side of the fence and we're good. And the other way that patents can be used defensively is, if you are the unfortunate recipient of a cease and desist letter, or you are sued for patent infringement, if it's a direct competitor and you're both making products that's similar, you might have some patents that maybe they could potentially be infringing. So if you're in district court litigation as a defendant or any litigation, you can countersue. So even though you're being sued for patent infringement, you can say, hey, well, I think you're infringing on our patents. And so this all seems kind of hostile, but I think sometimes asserting your rights and not just having those rights asserted against you can kind of help get both sides of the table together and say, okay, what are we fighting about? maybe there's another way to do this that's less expensive than, long drawn out district court litigation, because there's lots of attorneys involved. It can become expensive. Maybe we can come to a resolution that's the form of patent licenses. So we can all work in this space and stay on our side, or maybe we somehow come to some other agreement where we stay on our side of the fence and don't encroach on your side of the fence. So, what those agreements end up being as a form of settlement, just depends on the circumstances. But if you have your own property right, patent property rights, it kind of may help you assert your positions more strongly. And then, there are two main buckets on how to defend against a patent infringement lawsuit. And one is to say, hey, we don't infringe, our devices don't infringe on your patents, and here are the reasons why. And the other bucket is generally to say, you know what, we think your patents are invalid, and so you can't violate a property right that shouldn't have been granted in the first place. And so generally what that means is, as Jessica was discussing earlier about all the requirements to obtain a patent, like the substantive requirements, like, right, you have to be novel, it can't be obvious, the written description, all of those substantive areas of analysis that go in, that are reviewed during patent examination. A challenger to a patent can say, hey, like, I know the examiner, looked at this stuff, but they didn't look at everything. And we think there's other prior art in this space that actually predates this invention or this patent application. And so this patent actually is not novel because there's other prior art out there that predates this patent filing. So we think that this patent shouldn't have been issued in the first place. So generally speaking, those are things that one can do. I mean, the last point doesn't have to do with your patent rights per se, but it's just a part of the, usually a part of the litigation strategy. So, how does this all affect the patent owner, particularly one that is maybe a startup? So, having patent rights, it provides a right to exclude others from copying your product. It's a way to enforce those rights. You can use patents to generate more revenue if you would like to maybe license those out. And it's also a defense. It also signals to investors that you're serious about your technology. I think it provides some comfort that if, if there are copycats, you have patent rights that you can assert and try to protect your technology. Like, you'd have recourse if there was someone else that came out there and try to, make a wingding that was similar to your doohickey. You don't want to, it provides some type of, not necessarily tangible asset, but it is still a property right. So it is useful, particularly when you're starting out. It gives you a way to, anyway, yes, it gives you a way to like monetize your technology. And that's all I have.
Thank you, Monica. Yeah, I think that point there about it being a property right, I know a lot of inventors, takes a little while to think about it. If somebody took your physical property, a car or something like that, you could report it to the police and the police would enforce your property rights. The unique thing about intellectual property rights are you, the owner, has to actually bring a lawsuit against somebody to enforce your property rights. So some inventors don't realize that and realize you actually have to spend money to enforce your rights, unlike other property rights. So takes a lot of money. Patents are not cheap, and neither are enforcing patents. So great. So I'm going to stop sharing the screen. So that was the end of our substantive presentation. I was going to see if there was any questions from the audience. I don't know if we can use the chat feature here. If anybody had a question for us on general IP stuff, we could answer it now. Is the chat feature enabled? I just want to make sure.
It's a really good question. I did prompt everybody there, and I didn't see any responses. So
Okay.
Maybe a smart idea at this point is just look for raised hands. It looks like I saw Dr. Abe Lee raise his hand. There we go. Let me see if I can get, here we go. Go ahead, Abe.
Well, I was just going to respond that it says that chat is disabled. So
okay,
just want to reflect that. But yeah, it was great. I really enjoyed the session.
Thanks. Maybe we'll move to the hand raising idea. So yeah, so.
Oh, I see a Q&A or something.
Oh, there we go. Yeah.
Oh, somebody asked the question, are method patents less enforceable than device patents? So anybody want to take that one? I can try. No. So I don't think they're any less enforceable than device patents in theory. You know, an example that often comes up is in the medical device field, you can get a surgical method patent in the United States, and it is perfectly enforceable. What you might have is more difficultly proving infringement sometimes, because when you have a product, you can pick it up and kind of prove infringement by just looking at it and saying it has this feature or another feature, where a method patent might require more additional evidence of infringement, because you got to figure out what people are doing, how are they being instructed to do something, or are they being encouraged to do certain steps. But so I would say that it's just as enforceable, but might have more challenges on determining or detecting infringement than device patents. Any other panelists who disagree with me or want to put their own color on that? Go ahead.
No, I agree with you. I think especially in the medical or life science field, the thought of suing your customer is not great. And so you're always working through indirect infringement, that your competitor, induced them or, had them infringe. Method patents are still valuable in the US and, the other countries that let you get them. I find in my practice that you can sometimes get broader method claims. It's a little harder for patent examiners to find exact prior art method steps to try to narrow the scope of your method claims. And so it's always good, I think, to have a mix of both.
I think that's the point. I would have both. And that's always often the answer for a lot of patents. And you can get more than one patent on an invention. You can actually file an application and divide it up into continuations and divisionals. So there's a clear question here, but and I'm going to answer this question. What if company A files a provisional within a 12-month period, company B files a full application? Will company B be blocked? I think the answer there is depends, but I don't know if anybody wants to take a stab at that one. I think it depends on what's in the provisional, I think. But does that anybody want to take a Brian or Iman or?
Yeah, and I think if I understand the question correctly, so I guess to be fully clear, it's a first to file system. So if company A files ahead of company B, and what company A has filed on is effectively all of what company B has filed on, when the application of company A publishes, assuming that they proceed to a non-provisional application within 12 months, will preclude company B from claiming the exact same thing as what is disclosed in company A's filing. Because company A's filing will effectively act as the prior art to company B. And so there's a lot of little stipulations that kind of went into that answer. I don't know if anyone wants to add any further color to that, but that's kind of the short and dirty answer to that question.
Yeah, so maybe just kind of get to the point. It doesn't matter. A provisional is just as good as a regular application. What really matters is what is in it. And so let's say your provisional was very poor. It wasn't complete and was maybe missing a lot. And then somebody else files an application after you, but it has a lot more detail. That answer may get more complicated. It may be that the first person is entitled to invention on some things and the second person may be another. But if they're both equally detailed, provisional or regular, first to file wins. There's a question here, and I think this is a good one. Does anybody have experience in discussing patentability with patent examiners if patent examiners do not agree with the patentability invention? So maybe somebody, we keep talking about examiners. Does somebody want to just talk about who examiners are and what it's like to deal with them? And I think that gets kind of at this question of, how do you deal with an examiner that disagrees? You want to take that one, Brian?
Sure, Robbie. So in general, patent examiners are the government official that basically it's kind of like a judge, but not necessarily. They don't have to be a lawyer. They can just be someone that's very has technical expertise in the specific application. So what happens is your patent application, once it's filed, there's some initial screening based on they kind of look at the title, they look at your abstract, they see what the patent application is about, and they assign it to the patent examiner. And there's, I think, thousands of patent examiners at the US Patent Office. And, they take a look and they compare it to, what's out there in the prior art. So they do a search. And from there, they kind of determine, what happens to your patent application. And, the most common thing is a first action rejection. That's what the patent office does. Like 95% or more of the time, they will reject your application. And that's not the end of the world, because you have several rounds, at least 2, to respond, and potentially more if you just want to pay fees to continue that prosecution process. So if they don't agree, typically, like with the first rejection, you have the opportunity to respond in writing. But a lot of times it's very good to actually do what's called an interview. So you have the opportunity to, before you could always just kind of go to DC in person, but now patent examiners kind of work all across the country. And a lot of times you can have either a phone or a Zoom interview. So a lot of times you can just develop that personal relationship with the patent examiner by talking to them. You can present slides, you can show them pictures or videos of your invention, and really get them to say, hey, here's something that's important. For whatever reasons, you have an actual company, for example, you kind of explain why the reasons that you are doing this. And I think doing interviews really helps to sort of personalize it and humanize that for the patent examiner to try and get them on your side.
Yes. All right, there's a couple more questions that I think would turn a little bit to the career path, because there are some questions about that. So one is kind of a very specific question. It's about a startup collaborating with a large company within NDA, and then the larger company goes and secretly files a patent application on the startup's IP. How can I find out about this without having to wait 5 years for the full claims to be published? Again, no specific legal advice here, but on a high level, this is not an uncommon thing, right? That's why you have it. Even if you have an NDA in place, it doesn't stop somebody, a small company or large company or any other company you're dealing with, from taking your idea. That's why you may watch publications. You often get a hint of this if a publication publishes and you see something in it that you actually gave to the other side. So you can monitor publications, and those publish 18 months. So you don't have to wait 5 years. You actually see within 18 months of them filing if they potentially took something for you. And then it gets complicated. There could be a lawsuit involved here, cease and desist letters. It's going to come down to the NDA. It's going to come down to proving where the ideas came from. But the great thing here is you have an NDA in place. So at least that's the most important thing, because you won't be able to enforce all these other rights without having some contract in place. So the last question here is there a different culture around patents for software technology and AI as compared to other types of technology? Particularly given the open source kind of environment and collaborative attitudes. And there's not a specific software engineer here, but I think we've all dealt with software patents and engineers. Anybody want to make a comment on that?
I can. So I like to think about software companies on one end of a spectrum and life science, biotech, pharma on another. So for software companies, there are thousands of patents out there that could cover their product, and their product is changing very frequently. So they will quite often not even look and see what else is out there before they start selling products. This is obviously generalizations here, but just kind of generally speaking. And so they prefer patents to be less powerful. On the opposite end of that, you have pharma, life science, biotech companies where every day a patent is valid, it's worth millions of dollars to them. And they're on the opposite end because maybe only 1 or 2 patents cover their full product. And so they're really thinking about the strength of patents, and they want to see patents be as strong as possible. I like to think in a medical device company, we kind of fall in the middle, and we're actually right because we can see both sides. But that's just me.
Great. All right. So we have a few minutes left here, and then I thought we'd turn now to maybe some career talk. So just real quickly, we go through each of the panelists. Maybe just tell us. I'm gonna start with Monica. Tell us a little bit about your journey to becoming a patent attorney and why you became a patent attorney.
So I had, when I was in college, I thought I wanted to be a professor at a university and have my own lab. And so I went to grad school because that's what one does. And then, in grad school, still, I want to be a professor. I got to do a postdoc. So I went and I did a postdoc, and, been aware of how funding works in academic institutions and all the administrative aspects that apparently nobody likes, but they just kind of deal with. And I guess once I got to the postdoc, that's the last step. I mean, not really anymore, but like kind of, now, the next step, I have to apply faculty positions. I don't know where that's going to be. I don't know, where will I be living? Like, will I even get a job? I have no idea. And I guess being faced with that reality that was a lot more closer in time than it had been, I guess I just kind of like, well, I don't know if I want to do this anymore. I moved for my postdoc, and that was fine because it was a terminal position, and, I enjoyed Seattle. I was like, that's fine. I'm having a good time here. But then I don't know where I'm going to live next, and I don't know how long I'm going to be there. And there's all these other variables, and I don't know if I want to keep doing this way. And I had some other frustrations too that I won't get into, but so, I tried to figure out, well, what can I do with my degree? I wasn't really interested in being in industry. I didn't want to be at a teaching institution. So I guess I'm saying goodbye to academia, but I kind of like this. I like learning about new technology a lot, and how can I be close to it, but not actually do it anymore? And so I came across patent law, at some alternative careers seminar at University of Washington, and it was given by an attorney, I think at Wilson Sonsini, but the Seattle office. And so I reached out to him, and I got an informational interview with him, and that informational interview turned into like 2 or 3 other informational interviews with individuals who had come from research, had PhDs, and then decided to go become attorneys. And they all liked what they did. And it's like, it's a good way to kind of keep your foot in one sector and then in another. I mean, you got to go to law school. I guess you don't have to, you could be a patent agent. I decided I didn't want to just be a patent agent because I thought maybe I would like litigation. And so you need to go to law school if you want to do litigation, at least in district court. So that kind of set me off on that path. And so I went to law school. And I think for me, it was the right decision. I spent a lot of time in academics, but I don't regret that time. I use it all the time, even though I'm not prosecuting patents. I've never done patent prosecution, but, especially being a more junior attorney, I'm often the one that has to figure out how the thing works. And is there infringement? Is there not infringement? How do we invalidate this? How do we, argue against invalidation? All that stuff involves really knowing the facts of the case. Facts of the case are it's the technology. So it's very helpful to have a technical background, even if it's not, I've never done anything related to my PhD. I don't expect to, and it doesn't matter. Just how to investigate things. Like you were trained to do that. That helps a lot. So that's kind of how I ended up where I am.
How about Iman? How about you? Tell us a little bit about your path.
Of course. So mine's rooted in entrepreneurship, actually. So during my PhD, I was inventive myself. I loved it. And I found very quickly through an internship I did at our technology transfer office that intellectual property really serves a cornerstone of early stage innovation and entrepreneurship. and I fell in love with it. You know, I'm a big nerd, as a, you know, probably a majority of us are, and I love writing papers, reading papers, and just fascinated by knowledge in general. And I saw the value and the economic incentives of patents, and it was just incredible. And so that kind of one thing led to another, and I had colleagues that I worked with that had taken the patent bar or in law school, and then I took the patent bar. So kind of to what Monica was saying, you actually don't need to be an attorney to be a patent prosecutor, which is someone that goes back and forth with the government, as we've been talking about, the examiners, to get your patent allowed. So I don't have a law degree yet. I'm in law school right now, but you don't actually need it at all to do my day-to-day. You just have to take and pass the federal patent bar. And so I did that. And now I'm here at Wilson Sonsini, excellent firm. Nothing against Kenobi Martins, Robbie and Brian. Also a great firm as well. They just have very good incentives in terms of providing for their patent agents to go to law school. They pay full tuition reimbursement as well as my salary. And I have a reduced hour requirement. So very much incentivized to kind of grow in the career as well. So yeah, basically rooted in entrepreneurship and my interest. And now being in this kind of position, I see myself in my clients, and it makes me really love and appreciate their innovation. And I just really I latch onto that kind of that novelty and the newness of all these fascinating inventions that come through my door. It's just absolutely mind blowing. It's like being in a different labs all at once, and you get to see all the new stuff. So it's really fascinating.
Great. Jessica, how about you? You also you were a patent agent for a while too, right?
Yes. Yeah. So my training's in mechanical engineering, and I wanted to be an engineer, or maybe thinking, you know, head towards business at some point. But similar to Iman, I took a fellowship and did some inventing in the medical device space early on, and similarly just really saw how important patents are to inventors, to startup companies. I mean, they are the asset that gets bought and sold, and just really valuable. And so being able to know about that, I found really important. And then the other factor, again, similar to Iman, I worked as an engineer for a while. I did some medical device stuff work. I actually had a really cool internship at GE Aircraft Engine. But I saw, you know, a lot of engineers work on kind of the incremental improvement of the next generation of the device. And that is important. We need that. We need our inventions and our devices to improve. But I wanted to stay at the beginning, because that's what I loved. I love the inventing, I love the innovation. And so patent law really lets you get to stay in the beginning and work with people who invent, who are really cool. So that's what drew me to it. And yeah, I worked as a patent agent for a long time. So after my master's in engineering, just went straight into doing patent law. And I wanted to make sure I liked it before I invested in law school, which I'm actually really grateful for, because then I could find out that I really did like it. Two, I decided that I did want to have it. Not everyone, you know, some people love being a patent agent, and that's what they want to do. And so why bother going to law school? And then also, I was older when I went to law school, so I felt like I had kind of better perspective on life. I could really enjoy the learning part and not get too stressed out. And so I'm glad I, you know, took the path that I did. And then kind of like what Monica said, was also really interested in litigation. And so after law school, I clerked and did litigation, specifically appellate litigation. I even got to I got to write briefs for a case in the Supreme Court, which was amazing. And then decided I really was missing medical devices, and so wanted to get back into industry and move back in-house. And the last thing I'll say is, you know, so my job now is really more a generalist. And so I think the combination of having an engineering background and an understanding of the law has really allowed me to kind of take my career wherever I want to go. So my day is anything from employment law to contract law to, you know, healthcare regulatory law, and, you know, a lot of patents along the way. But it really has opened a ton of doors for me.
All right, Brian, you have a unique background. In case you didn't catch it, Brian Wall has an MD. He's a doctor, still practices medicine, and he has a law degree. So a lot of school for Brian. So why so much school, Brian?
Thanks, Robbie. I ask myself every day sometimes, but it's been an interesting path. So I did an internal medicine residency, and I actually thought back in the day I was going to be a cardiologist or maybe a critical care doctor. But I kind of wanted to have a niche, but kind of just had a half-baked idea. So on a whim, I just went to law school, thought about medical malpractice, but that was kind of too close to home for me. I thought about public policy, but I thought, well, it takes too long to influence the government. So kind of ended up in intellectual property. You know, I interviewed bunch of firms at Kenobi at the time. There was, a few other MDs, JDs there, and they were nice. And there's a lot of great engineers like Robbie who were really cool too. So I'm like, all right, this is a great place to be, and ended up there for, over 15 years in patent prosecution, building portfolios for life science companies. And it was kind of great from being, on the front lines in medicine and as a clinician to being on the leading edge of innovation. In patent law. And I think one of the keys is the opportunity to amplify impact, right? Because you can help, one client at a time, or if you're an engineer, you may work on one project or a few projects, but having the opportunity to be on the bleeding edge of innovation to help with, devices or pharmaceuticals or, biotherapeutics to help millions of patients, I think is really an awesome thing. And I think it's a really great thing in the field. I mean, you can be at a really respected great firm like Robbie or Iman or Monica, or you can be in-house like Jessica and I, and you really see like a lot of great things on both sides of the spectrum.
Right. And I'll just echo my journey. One thing that really attracted me about patent law is I worked as an engineer for about 3 years, and towards the end of my engineering career, I was feeling like I was getting pigeonholed into one space. And so I was really looking for a career that would allow me to maybe diversify the type of technologies I would see. And that's been, I think, the biggest thing I like about my practice is I'm doing medical devices one day, but it could be a heart valve, it could be a heart device, it could be orthopedics, it can be robotics, it can be and then I can do non-medical device work. I do work for Starbucks. I do work for automobile stuff. And so I just love being able to learn about a lot of different technologies. I think, as Iman said, it seems like, and it changes over time. The stuff I do now is completely different than some of the technologies I did 10 years ago because clients change. So I think that's a very attractive part of law. So there was one question here, and I'll take a stab at it, but everybody else can also, because I think it's something about an opinion. So I'm a student asking about, do you need an advanced degree to be an IP attorney? And I think almost everybody here does. I have a master's. I think, Jessica, you said you have a master's, Iman PhD, Monica PhD, and MD. So at a high level, no. Particularly if you're going to do litigation, not everybody in litigation has an advanced degree. I do think and everybody can chime in after I'm done, and with maybe if they have any other thoughts. If you're going to do patent prosecution and small molecule chemistry, you probably need a PhD in chemistry. If you're going to do some very high pharmaceutical biotech patents, you'll disproportionately see people with advanced degrees in patent prosecution in that space. But for electrical engineers, computer science, mechanical engineering, biomedical engineering degrees, it's very common even to see people with just a bachelor's degree doing patent prosecution. So anybody want to comment on that, or think I got that wrong as a general trend?
No, I agree, but and I'm not saying this question was in this theme, but I have been asked like, hey, I just have an undergraduate degree. Should I go get a master's so then I can go to law school or some version of that? I personally don't think that's necessarily a good idea. I think if you would like to get a master's or some higher formal education in some technical, in engineering or life science or whatever, because that's what you want to do, then go for it. But I don't necessarily think that it's worth, I don't know, maybe if it's a course worth master's and it's only a year, but if you're doing a thesis, if you're doing research, it's a lot of time to invest just to then go to law school. If you're going to plan is to go to law school. So I think the question everyone should ask themselves is like, where do you want to end up? Do you really need all this extra formal education and some technical background? Probably not. I mean, there are exceptions, but it's a lot of time and investment to do something just to prepare you for another something. I mean, I did that, but it was on accident. I didn't like do these things to go to law school. I just kind of ended up where I am. So that would be my suggestion.
And I think for the audience might be helpful if somebody wants to take on this. Just we've been mentioning a little bit litigation versus what we call client practice or prosecution. Often attorneys do one or the other. You don't have, some do both, but we do tend to see in our industry people choose one or the other. Does anybody want to give a little bit of a high level thoughts on those two? I think you did litigation, Jessica, so maybe I'll let you tackle this a little bit.
Yeah, sure. I love both. And I think having done both made me better at each one. I did prosecution, then litigation, and then went back to prosecution for a little while. And, you know, the nice thing about working in patent law is you can try both. And the way early on in your career, and law firms really encourage you to try different things and get exposure to different things, and you can see what you like. I found, you know, so prosecution is fun. You're meeting with inventors, but you're writing a lot. So you're kind of sitting alone and writing a lot. But I love that. So that was fine. And then the meeting with the inventors was super fun. On litigation, it's more adversarial. You could get stuck with emotion, you know, Friday night, and it ruins your weekend. And yeah, Monica knows. But it's exciting, right? And you might get to go to court or go to trial. And so I think it kind of depends on personality and what you like. And so I would encourage you to try both and see what you like.
Yeah, one other thing I just want to mention is there was a question here about how did you decide to go to law school or what skills? I do think at some point you do have to realize that as an attorney, whether you do client practice or prosecution or litigation, you do need to communicate well. And that means you will be doing a lot of writing. You will be doing a lot of speaking and listening. And so that's one aspect of being an attorney that is just going to be there's some engineering jobs where there's a lot of that also, but the degree you're gonna have to do that in law is going to be kind of up to notch. And so there's a lot of pressure to write well and speak well in law. And so that's just something to think about as you go into law, into IP law.
Yeah.
So we have a few minutes left. I was trying to skim through here if there was a question we missed, or did anybody else want to have any kind of final comments, or Song or Walt, any kind of questions you have for the panel as we kind of wrap up here, or any final comments for the group?
Linda, you're muted if you, yeah.
Yeah, I saw. So actually, I'll ask you guys one from back when I was doing a lot of biotech. Actually, you talked about, you know, publications being bad because you invalidate patents, right? But you can also use them as a positive, right? If you don't think something's patentable, but you publish really fast, that precludes other people from doing it as well, right? Is that also a strategy that you recommend?
I don't know. I'll take a step. I'm not sure I recommend it. It is true though. I mean, if you publish something, it does kind of prevent other people from patenting it. I'm a patent attorney, so I'm always worried about that. I'd rather err on the side of trying to get my own patent on it. But there's a aspect to that is true. By publishing your invention, by using your invention in the public, you do put a line up there that nobody else can get a patent on it. Anybody else wants to comment on that?
I mean, one thing to consider, there are often technologies like Volvo invented the seatbelt and they wanted other people to use it. But instead of not filing a patent and then just putting it out in the public, they filed patents, but then, you know, agreed not to sue anyone. And by owning the patent, you have a little bit more control over how that invention is used, who gets to use it, how it's used. And so, you know, even if you wouldn't want to enforce a patent because you want it to be out in the public, it's sometimes nice to have a patent and then you have some, you know, say in how it moves forward.
And maybe one other thing, if you could address this, I know sometimes because the undergraduate students are told that, you know, one of the differences between being an undergrad and a graduate student is the undergrads own their own IP as long as it's not something they're doing in the professor's lab. So could you speak to that a little bit? Like if you're working on a capstone project, is that considered part of the university? Is there situations where if the undergrads come up with something specifically that it wouldn't belong to the university?
I actually wrote a paper on this in law school, so I'll take a first stab at it. It really depends. So I did a survey of 50 universities and what their policies are. And it really depends on the university specific policy. So I really encourage all of you to go to your tech transfer office. They'll have the policy posted and read through it and ask questions about how that applies to you, because it's really important to understand it. Typically, undergrads, unless you're employed by a lab or working for a professor, which sometimes happens as an undergrad, you will own your own inventions. But grad students, faculty, staff, anyone being paid by the university, they've typically, through their employment agreement, have agreed to assign over any inventions they have. And it's not necessarily a bad thing. When I was working in grad school with inventions that were going through the tech transfer office, they're professional licensors, right? Like, they want to get the patents out there. They can make introductions to big companies. And so don't necessarily view it as a bad thing if your university owns your patent. Oh, one last thing. I would say it may be questionable whether a university can enforce a patent policy against an undergrad if they weren't employed by the university, if they had a policy where they took undergrad inventions as well. Questionable enforceability, but it hasn't been proven out yet. So,
yeah, and I would just add that, yeah, like I think just said, it depends. It's going to depend on each university's handbook, the contract you have, and if you sign any agreements. Like in California, there are some limits about even what an employer can own, what an employee does. And so if you read that, there's a statute in the California law, and some factors to think about is what you're inventing. Are you doing it on company time or using company resources? And you can apply that to university. Is it related to the work you do for the university or your company? The more related, and these are factors that come up. And then, so the less related and the more it's on your own, or if it's completely on your own time, there may be more opportunities for you to own something. And the more you're using your company's resources, or it relates to what you actually do for the company, the more likely you might fall into some contracts that you have. So, any final comments, Walter?
We did have someone write in and ask for contact information of panelists, which is a great reminder. If any of the panelists are able or willing to share contact information, please, yeah, go ahead. Robbie, you got any good ideas for that one?
For me, you can see my name on that screen. If you just Google my name and Knobbe, Knobbe, you'll get to my webpage and my email address. So,
yeah,
are most of you on LinkedIn? Could the kids reach out to you on LinkedIn?
yes.
Yeah, that's probably the best way to do it. I'm on LinkedIn. Just look for Jessica Hudak and Edwards, and I'll pop up. And I'm always happy to, I love working with students, especially ones interested in patent law. So I would welcome any questions anytime. Happy to talk to anyone.
Same here.
The only closing question I could think of was, we've talked tonight about people who've pursued kind of STEM education and then found their way into law. Are you guys unusual? Are 20% of your circle kind of trained in science and engineering, 5%, 30%, what is about the right mix?
I don't have a number on the top of my head, but yeah. I know in my law school, which was UCLA, out of 300 students, there was around 10 of us that had tech degrees.
Wow.
And so I don't know if anybody else, I'm seeing a lot of yeses from people's head. I think it's still like that at a lot of schools.
Yeah. I think some schools maybe have a higher percentage, if they tout themselves as a entrepreneurial school or a technical school, you might see more patent attorneys there, but yeah, pretty small.
Yeah, I always forget that a lot of us are lawyers, so we don't realize this. There's not a major in law school. You don't get a IP law degree, you get a law degree. Certain law schools do offer more classes in IP law. But it's not like an undergrad degree where you kind of like isolated from all the other students. You're in the same classes with everybody else, but you may take a couple extra, like I said, intellectual property law classes, particularly in your second and third year.
But I will say, as someone who, when I was at Amgen, interacted with multiple different IP lawyers. For the scientists and the engineers, the only IP lawyers we ever want to talk to are people who have a science background, because it's just too impossible otherwise, right?
Yeah, definitely.
Giant help.
Yeah.
Hey, I did notice we had late breaking panelist, Professor Abe Lee. I mentioned his name earlier from UC Irvine. He's the chair elect, I think, of the Bioengineering Institute of California. Abe, do you want to say a word before we close out our panel, or don't know if you are listening, or if you can unmute?
Can you hear me?
Yeah, you sound great.
I just heard my name and I was running upstairs because my son and didn't quite get what you were saying. So could you just repeat?
No, never fails. We're kind of at the tail end here, and just thought if you'd like to give some thoughts or comments.
Oh,
to
I
the
see.
students.
Yeah, definitely. I just want to thank the panel. Just an amazing group of I think insights, and this career is, no matter what, if you're going to take a career in legal, I think nowadays innovation and invention and STEM in general, you need to know all these aspects. And regardless of academia and postdoc, or going to industry, or even starting a business, this is all relevant. And I think maybe a few decades ago, or maybe 1 decade ago, it's not as, you don't think it's as relevant, but now I think everything's so intertwined. A lot of the traditional lines are blurred in terms of like AI and all these technologies that are coming up with biotech and gene editing. These things just blur the lines between invention and what is invention, what is technology, and who gets what. There's a big lawsuit I know people know about in terms of, sorry, I just ran upstairs. Invention between the, I think the Berkeley and MIT in terms of the CRISPR. So those are just fascinating stories, but I think we're all more and more involved and just can't avoid it. So might as well embrace it. And so I think it's great that I think the panel gave us a starting point for many of us starting out, but in terms of even people like me, been around for a long time, just benefited a lot. So just want to thank everyone just putting together this fantastic panel.
Excellent. Linda, please close us out here.
Just, I think to echo what Abe said, on behalf of the BIC Steering Committee and the Industrial Liaison Committee, thank you guys very much. This was an excellent panel. And, letting the students have your contact information is really fantastic. And I also want to thank the participants. So we actually had a lot of good questions. I know that's always something I wonder about when we're doing these kinds of events. So thank you guys very much. And, for the students, stay tuned. We'll have a different career panel sometime later this year as well. So take care, everybody.
Thanks very much, everybody. Have a great night.
Thank you.
Thank you.
Good night.
Good night.